his committee meeting, and we welcome you to our first roundtable. The first topic is going to be inadmissibility versus confidentiality. We decided to do this because in our committee meetings, we have been having very exciting discussions. I know that sounds funny, but we get into debates and we have these wonderful discussions, and we realize we don't have all the answers, but we've got lots of questions. And the group that is on the committee has a lot of experience and brings that experience to these discussions. So we will just get started, and each person is going to identify themselves. You probably know everybody who is here, but when they speak, they will just tell you a little bit about themselves. And I'm Ann Anderson. I'm the chair of the committee. But we thought we would just go ahead and get started. And the first question that I have is just about the general rule. And Tara, if you'll just talk about the general rule about inadmissibility and confidentiality in mediation. Because in the past, when we first got started in mediation, people were assuming that everything that they said in mediation was confidential. And so Tara can talk a little bit about that. Thank you, Tara.
Yes. Thank you. Good morning, everyone. My name is Tara Kozlowski, and I am the Executive Director of the Dispute Resolution Commission. I see a lot of familiar faces, so I'm very glad you were able to join us this morning. This is a great topic, and I'll tell you that we have an advisory opinion that speaks specifically to this issue. It's Advisory Opinion 29. And basically, what it does is it explains that the mediator's role in their opening remarks is to describe the difference between inadmissibility and confidentiality. Confidentiality under Standard 3, it applies to the mediator and only the mediator. And the mediator may not disclose, shall not disclose to any non-participant, to court staff. We're very, very limited on anything that we can talk about. We can't speak to conduct of the parties. We can't share information, share stories. If the parties want confidentiality, then it's up to them to enter into their own agreement regarding that matter, but it's just for the mediator. Where it comes in with inadmissibility is the two statutes that govern Superior Court and Family Financial Mediations, 7A-38.1 and 38.4A, talk about inadmissibility. And the ability to bring this topic into other matters. And the statute protects the discussion and the mediation surrounding civil claims that arise out of the matter that's being mediated. It does not protect other civil claims, and it does not protect criminal actions. So our advisory opinion talks about an attorney who is in a civil mediation, but there were pending criminal charges related to those same matters. And the attorney for one of the parties was subpoenaed to testify in the criminal action. And the judge allowed them to do so. So there is a very bright line between what's admissible and what's confidential. And it's important that the parties understand, especially if there are pending criminal charges related to the action that you're mediating, that the confidentiality that the mediators are bound by does not protect them, okay? Now, there are rules of evidence that apply, obviously, regarding content from settlement negotiations. That's gonna be up to the judge who's on the bench to determine what they will let into evidence and not. And I'll tell you that the commission does not expect anyone to go to jail. So by all means, take the rules with you, take the standards with you. If you get subpoenaed, call me, we'll try to get you out of it. If it's a criminal action, we'll do what we can to make sure that you avoid it. But if for some reason you ever find yourself as a mediator on the stand in front of a judge and you've handed them all of the advisory opinions, the rules, and you've done everything that you possibly can, please do not go to jail for the commission. Okay.
Thank you, Tara. So, so the rule's been around for a good decade, if not longer, but I still, Ray and everybody else on the panel, what's your experience with what attorneys and parties know about confidentiality and mediation?
Well, Ann, it's my experience is kind of yours. I think originally I got so insecure about it, I went back and looked at the rules because I said, maybe I don't understand this rule, because you did hear frequently lawyers, and this is the most fragile part of it, lawyers advising their clients, don't worry, you can say anything to him. He's not very smart, but he'll keep everything confidential. And, how do you, as a neutral, when you have this, you have your lawyer and your client who trusts her, how do you say, well, it's really not quite like that? And you go through this explanation that I know everybody here has had to do. Not really like that. We're different, and so forth. It's only confidential as to me. And then you have to explain what I call intra process confidentiality. Now we can have it, but there's actually a reported case. And meanwhile, they've fallen asleep while you're giving them all the Miranda warnings about confidentiality. But the interesting question, interesting only to lawyers, let me quickly say, is if you get a call from out-of-state counsel and your mediation is in a couple of days, and they do have local counsel, let's say it's a high-profile matter and very sensitive matter. They've already had publicity, could be a products case, could be a corporate case, could be sexual abuse, anything that has had publicity but been very sensitive. Can the neutral even raise this subject? That is, we're odd in North Carolina. You need to know our process is not inherently confidential, unlike many other jurisdictions across the country. Can the neutral even raise that question, or is he or she going from preaching to meddling by even raising it? Because as soon as you raise it, most lawyers out of state will say, I had no idea about that. And then can the neutral then say, well, you need to talk to your opponent about whether the two of you want to have a confidentiality agreement or not? But I've always wondered, am I moving into an area that is not neutral? Because obviously at the end of the process, I wouldn't be suggesting terms and approaches, but can a neutral even raise that issue? So I throw that out for everybody on the call, but that's kind of a second cousin, if you will, to the whole confidentiality thing. But I think, Ann, I still hear it. And we just have to gracefully disabuse people of that notion, and particularly their clients.
And Ray, I think those are great points. So one, North Carolina's rule is not the same rule as other states. Other states actually have confidentiality as the rule. And North Carolina doesn't. So you have to be aware of that with other attorneys who call in. But I mean, Trish, Ken, and Jackie, what do y'all do? What do you think if somebody raises the issue that this is a sensitive matter, we need to keep it confidential? What do you think about suggesting a confidentiality agreement or telling them that they need to keep it confidential some other way? Jackie?
I mean, I would tell them that, if they want to keep it confidential, I would talk about confidentiality as to me, but if they want to keep it confidential, they're going to have a confidentiality agreement ahead of time. And then the question is, do we help them draft that? And I would say no. I mean, they they should be able to come up with something, the terms that they're going to want in a confidentiality agreement. I always, have questions about that, just in regard to enforceability. How do you enforce it? When you have a settlement and you say the terms need to be kept confidential, I think I think it can be found enforceable in that situation. But the pre-suit, the agreements before you actually mediate, I just, always have heartburn about those, except for, the thing is, when people sign those, particularly the individual parties, they really, understand and believe they need to keep it confidential. But I've always, had concerns about that. I do want to slide into talking about just what we say in the our opening statements, but I don't know if anybody else has comments about confidentiality agreement ahead of time.
Hey, it's like Kathan. So, the thing that they're mediating, the issue that they're mediating is really what I'm personally concerned about as far as the confidentiality and my confidentiality piece. as far as like drafting in a confidentiality agreement, to be honest, I feel like we need to be involved in that, not the drafting piece, but the terms, because like Jackie, you're probably at like 2,500 mediations or some crazy number like that, right?
Oh,
And
yeah.
so like think about how many more times you've had to think about confidentiality than all these attorneys who can only handle so many cases per year, you know? And so like your
Well-
experience and knowledge about what works and what doesn't work, what other people have done is vitally important, not in the letter of what is drafted, but the content of that document. So
Well, and I'll add to that, I might have done a little more drafting
In the
before
past.
things started happening with the state bar, and and that's something we can, Tara would have to address. That's when I slowed down my drafting, I'll say. But before that, I actually had sample confidentiality agreements for, pre-mediation, and when it was a situation where I knew they were going to want confidentiality, I would bring those with me to the mediation and say, if you want it, here are some samples, that have been used in the past. But now I'm more careful about that, and I don't know if Tara wants to help us with that piece.
well,
So
see,
you understand what I'm talking about.
I'd be less careful. I'm ready to get in trouble any day, all day.
Oh, me
Don't,
too.
this is being recorded, Keith. I
Yeah,
just want to make sure you
I
know
am.
that.
I'm right there with you, Kate, but it has started to give me pause when attorneys are saying, well, we need this in the agreement, and now I'm like, I hear Tara's voice in my head. So
All right, so I'm going to jump in, and Kathan's always in trouble, so that's nothing new. But
Yeah.
so what we do know, all right, we don't know everything, but what we do know is the state bar views drafting as providing a legal service, which would violate the standards because you're not allowed to give legal advice. As far as acting as a scrivener, they have no problem with that, but you have to literally transpose the information that you're given and collect it, but you cannot include legalese, any jargon, any clauses or paragraphs that you think the parties need to help protect them. You literally have to go off of what they have asked you to put into the document. The issue that is currently pending with the state bar is whether or not they are going to tag a mediator for acting as a scrivener who writes language that violates the rules of professional conduct. Okay. We don't know that answer yet. So the trick that we tell everyone is that if you want to act as a scrivener, you may do so. Make sure all parties are represented. Okay. Don't have a 10-party case with 9 attorneys and one little pro se party and think, oh, it's okay, I can go ahead and put this together. Do not act as a scrivener unless you've got all parties represented. If all parties are represented and you are comfortable that all terms that you're including in that agreement are on the up and up, then you are fine, free, and clear. Does that help at all?
No, but if
No.
you say when you say, like, not you, when the state bar says and all terms are on the up and up, you're saying please don't practice law, but then please practice law. Like
Yes.
that's not cool, or I mean, that's just not correct.
And that's why it's
Sorry.
still pending, because we're fighting it. Okay. We are truly fighting it because we tell our mediators you can't give legal advice. Well, how do you go and say, well, you can't put that in the document? That's going to violate so many laws. That's legal advice. So we're fighting it as hard as we can, but we're also doing it in such a way that we're trying to keep our mediators out of the mud. So for right now, the official stance of the commission is only put into a document as a scrivener, committing to writing other people's terms that you're comfortable with. And if you have a question about the legitimacy of a term, simply step back and say, you know what, you guys need to draft this and you guys need to put this into the agreement and step away from it until we get some clarification from the state bar.
So, and let's kind of go back maybe to the beginning of the question that Ray asked. I mean, what I'm gathering is everybody would be comfortable in raising the issue and telling folks you need a confidentiality agreement. Trish and
I think
yeah.
so, yeah.
Yeah, Ken, you do that with folks?
Well, not so much whether they need one, but whether they should consider one for
Yeah,
sure.
yeah, that's the way to
And I'll
word it.
say that I start out, I try to head it off at the pass just with my initial engagement email. I don't really have an engagement agreement or anything, just a, well, actually it's an email that becomes an agreement and hopefully they abide by it. But in it, I always reference confidentiality. I reference how I'm bound by the rules, and I tell them which rules I'm bound by. And then I say that the mediation is going to be governed by, these rules and the standards, and they need to review them. And if they want any additional governance for their confidentiality, then they need to affirmatively do it. And I want to address really one thing that Ray brought up as well, which is out of state counsel, which is, especially in the days of remote mediations, has become even more prevalent. You got folks coming in from California, from Nebraska, wherever the heck they may be. And like Ray said, they often think that there is strict confidentiality. But I will tell you this, they're only participating unless they're a party if they've been admitted pro hoc. If they've been admitted pro hoc, they're under their own affirmative duty to know what our rules are. And so, and then there's usually local counsel, but sometimes the local counsel doesn't abide by it. And so I've had to have some tough conversations every now and then when they start looking to me and I say, well, I reminded you about the rules. You are pro hoc. There's only so much I can go down. And then so that's that issue. But the other issue is very similar to Jackie. And I just don't think it's a violation of anything. If they're saying, okay, they haven't even thought of a confidentiality agreement till they get there at the mediation. So you're not going to put the mediation on hold for 4 hours. You're not going to reschedule the darn thing. That's just totally impractical. And so I have examples of confidentiality agreements that I usually give them more than one that I've either seen other parties do or that I've happened to use, and it is completely up to them. Now, I only do that when it's everybody's represented by counsel, and I'll just sort of kind of build on what Keaton and I think a lot of others are thinking. If you're represented by counsel and the counsel are looking to you as the mediator to provide some guidance within the mediation process, to limit our ability to do that when we're not making the decisions, we're just giving them information. I just think is really a decision being made by those who don't really know the realities of mediation. And that's my position on it.
Frank, do you have a reaction? Have you?
No, in general, I agree with Ken and Cathan. Cathan says a little louder than I would, but
Yeah, so I put in my, as Ken says, my engagement letter, email. I notify them that we don't have confidentiality in North Carolina, and if they want that, they need to have an agreement. And since I put that in my email, I haven't had any problems with it. I used to have people showing up all the time, being surprised when I would say that it was not confidential. And the rule was,
I'm sorry, let me interrupt and ask, do you tell them, however, it is inadmissible?
I'll have to go back and look at it, but I don't know if I
Okay.
say that.
Just
I'll have to go.
curious.
I wrote that a pretty good while ago. Ken, do you say that in yours?
I don't talk about inadmissibility in my engagement, but I always do it in the opening statement that I give to them, when we have the opening of the
Well,
mediation.
and so that's a good question. So let's get into, what do you tell people? I mean, I know most of us, when you start talking about confidentiality and inadmissibility, if you go into too much detail about any of this, people's eyes are glazing over. They're not paying attention to you. They're thinking about what they want to do in the mediation. Trish, how do you handle that when you're in the opening?
Good morning. I'm Trish Hall, a mediator in Raleigh, and I mediate primarily employment disputes and business disputes. So it's a question that I've often wondered if I'm doing it the right way. And so I'm really interested to hear the other responses. I do talk about how it's not appropriate to say one thing in the mediation, and then if the case doesn't settle, then down the road before a judge or a jury, you can't talk about what you talked about in the mediation and be contrary to what was in it. But beyond what's in the mediation, that's where I always, frankly, as a mediator, get a little bit stumped, because then you get a whole lot of questions to the point that Ken raised that can derail it for, 4 hours. And I do, from time to time, in a particularly sensitive case, go ahead and introduce the question in pre-mediation sessions with counsel of whether they want such an agreement, and then provide them, if they ask, with a sample. And then I understand we might even have a sample in the future. So.
So, and I guess what I'd usually do, I mean, I try to go through, give people some mediator advice in the beginning, but do talk about that, what you say in mediation is considered inadmissible, but I do mention that there are exceptions to it. And I just highlight a couple, but tell people there are others. But again, it gets into so much detail when you do that, that you
Yeah.
don't know if people are really processing what you're saying or not. Do you guys do that? Do you talk about the exceptions?
I reference them, but I'd reference them fairly obliquely. And if I give an example, I try to do it with a touch of humor. Like, there's exceptions out there. I doubt they're going to apply here unless somebody's packing heat. Anybody packing heat today? Anybody threaten any kids? Anything like that? And everybody laughs, and so we get past it that way. That's the way I usually do it.
Yeah.
And may I ask a question?
Yes, sir.
This came up recently with me in terms of, and it was both in-state and out-of-state lawyers were involved, and it was in an arbitration setting, and under the Uniform Arbitration Act, which says that the rules of evidence don't apply except as to matters of privilege and immunity. And so they then contended that the statements made during mediation were admissible because the rules of evidence don't apply. I did learn in exploring all that some states recognize statements in the mediation as rising to the level of a mediation immunity as opposed to simply being a inadmissibility issue. I don't know that North Carolina has ever faced that issue, but it was an interesting discussion we had.
That is interesting. So, so was it a statement from one of the parties that was admitted versus the mediator?
Yeah, they were arguing about the fact that they were free to exchange. In that case, the statements that they were arguing about were not only, they were primarily in that arbitration's settlement negotiations outside of mediation, but during the process of looking at all that, I realized that some states have a provision that mediation statements do rise to the level of an immunity, not just admissibility, and have a bar. I don't think North Carolina has that rule.
That's interesting. And Tara, I would don't know it. I've never heard about immunity. Now, Frank and I and Jackie, we talked about this. We're discussing a case in California where a court in a jurisdiction that said that statements in mediation were confidential. It was introducing a document to try to keep it confidential in the mediation so that it couldn't otherwise be discovered. Frank, you want to just briefly mention that because we've got a lot of topics to cover.
A developer built a Section 8 housing project, and was a project for poor people, and had a builder build the project. And of course, the builder and developer both cut corners as much as possible since it'd be a low rent project. And so it was terribly built. And so people moved in, masses of people got sick. Somebody finally tore into a wall and discovered there was water leaking in all the walls, and there was mold and mushrooms and everything else growing in the walls. So the developer moved all the people out. The builder came in and did destructive testing and took lots of photographs and and engineers to evaluate, et cetera. And then the builder and the developer went to mediation, and they brought boxes and boxes and boxes of discovery. And I'm sure made sure the mediator looked at every single page of it. Then they promptly settled the case. And so when the renters tried to get that discovery, they said, "Oh no, this is not discovery. This was created specifically for mediation, and it's confidential." And in my humble opinion, this California Supreme Court were fools enough to believe that argument And they said, yeah, it's, you know, what happens in mediation is confidential, and this is confidential and you can't get it. And so those two entities use mediation as a black hole to throw evidence into, so it could never ever see the light of day. And how are we in North Carolina have a specific sentence in our statute that says that is not true in North Carolina?
So let's kind of segue, because we've just got about 20 more minutes left into, so we've talked about, you know, what happens when the parties want to keep the information confidential, but let's talk about the confidentiality rule for the mediator, because we have a duty to keep things confidential. And so just, you know, generally the rule, when does confidentiality attach for the mediator? Tara, you want to just take that one?
Sure. Confidentiality attaches to everything for the mediator. You have very limited ability to communicate. We've got a few exceptions that have been very carefully defined under standard 3D. I recommend that you read through it, but it limits, currently the mediator is allowed to share files with staff for tracking purposes, conflicts, checks, etc. The commission is considering how to put guardrails on the standards to allow for a paralegal to come into mediation. I don't know how far we're going to get with that, but we are taking a look at it to see if we can create a system that would work for the mediators that would satisfy the commission. Confidentiality is so strict that the communication that you all have with the court staff is limited to what is required on the report of mediator. We have just revised all of the documents that a mediator would file with the court, asking for things like extensions of time or motions to withdraw, where you can now just check a box instead of actually having to list a reason. So we're trying to keep you guys safe by limiting the amount of information that you are providing court staff.
Good. Thank you, Tara. And so Jackie, let me come back to, so what do you say about confidentiality in the beginning for the parties, about your requirements of confidentiality?
Well, and I agree with Trish just in regard to, excuse me, sorry, I'm just getting over COVID and my voice is shot. In regard to, you know, we know what the rules say we're required to say in the opening statement. And then to yours and Ken's point about you send information in your email or letter about confidentiality and all, but, you know, the parties aren't really getting that. And what we say in the openings for the parties really, and the attorneys, and so you want to make sure that you're addressing that. And so I do talk about inadmissibility. I've kind of pulled away from, you know, saying hardly anything about the exceptions. And then on confidentiality, I talk about in regard to me, and, you know, unless they agree otherwise in the mediation itself. But I try to address more in the private session, to your point, Anne, that, you know, they're kind of like a deer in the headlights in the general session. When you're looking at them, they just, I mean, they're just not absorbing. And then also for the specific instances, for example, and I'm, you know, I don't really do many employment cases or, you know, the kinds of cases I mediate. I might run into more crimes, you know, just like if it's a motor vehicle accident and involves the DWI and they haven't had the trial yet for the DWI, then technically what they're saying could be admissible in the criminal, you know, proceeding. And so if I hear that that's what the situation is, I do address, you know, the exceptions a little more. Or if I've got a situation where there might have been threats, then I address it that way. And so, you know, if we get down into talking about all the exceptions, they're really not listening to us. You try to hit it, but you know, I do try to get into it more in the private session. And then to the confidentiality piece that Tara was addressing, and I've had some out-of-state attorneys, to the points y'all were making, where, you know, I do talk about that and they're surprised, and I just make sure that they know. And so I take that and expand on it in the private sessions where I know they're listening to me more and they need it more. And so I have the same heartburn though that Trish does. You know, am I going over everything correctly in the general session? But I do feel just pulling it to, you know, the private session is more effective.
Well, and do you, Ray, go ahead.
Well,
You
no,
raised your-
go ahead, Ed. I didn't mean to interrupt your thought.
Well, I was just going to say, so I mean, I have a presumption I tell folks about as far as confidentiality between the parties, you know, in the discussion, that I presume that I can tell anybody anything unless they tell me otherwise. And I know some mediators are different. Some mediators say, you tell me what I can tell them. And I may reevaluate that given how the discussion goes. I may say, I want you to tell me specifically what I can tell them. But I do also remember, Frank, you were teaching one time and you said, you asked the party, well, why are you telling me if I can't tell the other side? What good is it doing? Because you're not trying to influence me. You're trying to influence the other side. But
That is a tactic I will use occasionally. I've used it very, very rarely, but yeah, it is a strategy that I'll use to say, I'm not sure why you're telling me this.
yes,
What is
yeah,
the point of this conversation?
right.
Well,
right.
I'll just right before I leave the room each time, I'll just say, you know, I'm assuming everything you've told me is okay to share. And it makes them stop a minute and think about it. And then they'll go, well, maybe not this. I'll do that every time. And I put a little thing in my notes, okay, you know, to make sure I've asked, to make sure what I'm getting ready to say is okay to share with the other side. But I like to remind them every time, because sometimes I go, oh, wait, I shouldn't have, you know, don't let them know about this.
Yes.
Yeah, I agree with Jackie. I as the mediation caucus or proceeds, I will write a little asterisk on something that I think is likely to be confidential, but don't know for sure. And then before I leave each session, I ask, is there anything to be held confidential? And then I get the look that Jackie just said, and I say, well, you know, I marked this, this, and this. And I'm just wondering, am I allowed to disclose this or not? And that sometimes reminds them, oh yeah, there was that, because sometimes those sessions are long and they forget. So,
And that's a big fear of mine, that I, you know, I want to make sure I don't disclose something that the parties don't want me to disclose. And Ray, go ahead.
I will say, I'm
Well,
sorry
I was
for
gonna,
interrupting you. Well, I was just going to say, I think your notes where you've asked and you put, okay, you know, it's my process. It's what I do every time. And, you know, I think it protects you as a mediator as well.
I was going to ask something else, but I usually, in my canned remarks at the beginning of every mediation with everybody there, that's one of the things I talk about, which is I'm assuming everything that you're telling me is something you want me to take into the other side unless I hear otherwise, and put the burden on them. I'm like Frank. I think it's very unworkable when you walk into a caucus and a lawyer says, everything we say is confidential. And then, you know, an hour and a half later, it's up to the mediator to sort out, well, you know, because, you know, we have our own filters when one party says, and, you know, the other thing, he not only breached the contract, he's ugly and overweight, but what do you want me to say that to the other side? Of course, we're always filtering. But I usually politely reject that. I usually say, I really don't want to do that. You need to let me know what's confidential, because an hour later, and I'll also say, and I'm sure everybody in this room says, I don't think you should keep this confidential. I think this is something you need to share with them because of this or that, rules or the way the trial is or the summary judgment. And you have a good exchange with hopefully good counsel, and they'll say, yeah, sure. But I'm a little bit like Frank. I don't let them presumptively say everything is confidential, because that's very unworkable, I think. And also, as Jackie and Trish said, very difficult for the mediator. But it's you know, it's just it's one of those things where you're just, I don't think it's up to us to kind of gauge some of those issues, but that's where the mediator, I think, has a little more power in the process, and you can hopefully have enough relationship that you can kind of push back a little bit and just say, I just don't think that's effective or good, that we have to figure that out. But you can take care of it in your opening remarks. But I'm a little bit like Ann, you don't want to drone on, this is all about me and my 58 foibles. And, I also think people should stand up when I walk into the room and they no, we want to get on with our case, and you're a mere vessel. That's what they're all thinking. But at some point you could point to the fact, remember we talked about this in the opening session, that I'm assuming
Right.
thing you're telling me is I can take into the other room unless you tell me otherwise. And I always say the attorneys will protect you. Your attorneys know about that. They'll protect you if you say something that you don't want to have disclosed.
Well, and then of course, the thing they tell you to keep confidential, you go into the room and it's the first thing the other side tells you. I mean, I've had that happen. And then they already know about this thing that the other side wanted to keep confidential. So
the question I was going to raise so quickly, and maybe Tara, you're the one who knows this. I mean, we've all had this, you're at the courthouse or you're wherever and somebody comes up, I hear you mediated this case or that case, and you just kind of shuffle and look like a mule eating briars. Yeah, well, I don't know. I can't really, But what if it's in the public arena? What if there's been a newspaper article
and your name is in it? Yes.
Exactly. Lawyers Weekly. Is there ever a time when it's waived, if you will, by being in the public forum? Or must we always, Tara, say until our last dying breath, I'll never admit that I mediated Jones versus Smith? Is there ever a time when it's out there publicly, or is the
Always.
mediator strictly?
Yeah. So if it's in the public court file, you're fine. You can say I mediated this case. It's and as soon as everybody has Odyssey, anybody will be able to pull it up on their home computer to see who's been the mediator assigned to the case. So that's fine. What you can't talk about is the details of the mediation, the conference, the mediation was held. I was the court appointed mediator, I was the designated mediator, or just blanket, I was the mediator. And that's about all you can do. But if any information is out in the public, then it's no longer private or confidential.
So
Tara, let me chime in here on one thing, because I saw something happen in the local Winston-Salem Journal a number of months ago. 2 to 3 articles that built on this had a reporter digging into the court file a little bit, and they saw where a case had been resolved through the mediator's report.
Mm-hmm.
And they reported it in a way that sort of took the angle of it would have never been settled if there wasn't merit to the case.
Oh,
Really interesting.
oh.
And I almost picked up the phone. This was the court reporter here of saying, listen, don't be drawing those conclusions. But it's all the more reason why we've got to be really careful, and why I think it is good that the courts are keeping whatever is put on the mediator's report to the bare minimum. I'd never seen that happen before, but there were 2 to 3 articles that absolutely took that angle.
Yeah, and we've seen reported mediators that will state the case is settled, but defendant needs 3 months to come up with the $60,000 to pay plaintiff. And we're like freaking out over here, like, no, you can't put that in there, because it does become public record at that point, right? So that's one of the reasons why we are very strict on what you can include, including motions for extension of time. You can't say plaintiff is cooperating, but defendant's a real pain in the butt, and more colorful language that goes along with that, because that's public record all of a sudden, right?
Well, and so these are great questions, because Trish, we have talked about this.
Yes.
Because in employment cases, sometimes we're in a quandary, because there's the Older Workers Benefit Protection Act, in which the plaintiff may have a certain number of days to consider the agreement before it becomes effective. And that's by statute. So if you report to, and you're under a duty sometimes it's in federal court, to report to the court by a certain date. And so what do? The parties have settled the case. They just have to wait the statutory period. The federal court is a little different from the state court. While they're doing it for statistics, they are also doing it to hold the attorney's feet to the fire about meeting their deadlines. So what do you put on your agreement? So Trish.
And I just want to tag on to what Ann said, where I get frustrated, and I had one just last week where It was a wrongful death case involving a minor who was the taker of the estate. And so do I put on the report, it's settled subject to approval of the minor settlement? Or if it's a case involving a municipality, do I put the case is settled subject to approval by the Board of Commissioners or the City Council? And particularly in Fair Labor Standards Act cases where it's subject to approval by the court, period. So what are we, does the court want to know there's a but if in there or not?
And you know, in the federal court, I think they do want to know. So what are we okay with putting? I mean, you know, Trish and I were talking about, like, with the age case, that you could put subject to the statutory waiver periods. I mean, because that is what's happening. That is the time of the reporting the settlement. Tara, weigh in, please.
So clearly the commission only has jurisdiction over our programs. So we deal with Superior Court rules and family financial rules. But if you're certified, you're bound by the standards, which includes confidentiality, which you then have to apply to these other programs and courts, which becomes complicated. So one of the exceptions we have under confidentiality under 3D1 is if a mediator believes communicating certain procedural matters to court officials or staff will aid the mediation, then you need the consent of all the parties, right? So when you're dealing with something like waiting on a minor settlement, the parties just need to say, yes, that's appropriate to put in the report or to report to court staff. Potentially, if you can do it in an email and not a public record document, I would encourage you to do that as much as possible. If the court requires it to be in a public document, then it is what it is. You just want to keep it as vanilla and plain as possible. And you definitely don't want to say, wow, after 4 hours of me beating defendant over the head, we finally found a settlement and we just need this to sign off on. So just keep it and you laugh, but I've seen some strange things, right? Where mediators get frustrated and they want to put that emotion into the report. Like, I finally made it through this case and look at what a great job I did, but you can't. You just got to keep it simple.
And
I
so the
thought I've
moral,
been advised recently that like a DOT condemnation case, you settle it, but it's contingent on the board of review approval. I thought the commission told me to file that as an impasse and note on there that it was resolved subject to review by the review board, or subject to like some of these ladies said, maybe you have a municipal case and the town board has to sign off on it. I've been told I was supposed to declare an impasse and note that it was settled, conditioned on approval by the town council.
That's correct if it's a Superior Court case, because you cannot call a case settled in Superior Court if you don't have a final agreement. So the options is you have to impasse it and then hope that they jump the steps that they need to in order to settle the case and pull it out of trial court. Or you can request extensions if the court will give them to you until such time that you've got final approval by everyone. So that is absolutely right. In Superior Court or family financial, you cannot report the case as settled until you've got final documents on everything. That's a good point.
Well, I'll tell you one way that I try to handle it, especially with municipalities or counties. If it's got to be subject to the board approval, as long as that board's meeting in the reasonably near future, I'll hold the mediation open until they meet, and then the lawyers report back to me, and then I do the mediator report, and I show on the report that it was a continued mediation until this date, and then I do it. Because I'll tell you, if you're sitting out there and everybody's agreed on everything and you file an impasse for mediator's report, you'll have those lawyers screaming down your neck.
yeah.
Sarah, let me get clarification on what you said. If there are emails signed by both counsel saying that we've reached a final settlement agreement and that there will be future documentation, but the case is settled, can you file the report?
So it depends. That's where it gets fun, right? So we've got language in here. If the mediation settles if the case settles prior to mediation, and you've got confirmation from the attorneys that the case is already settled, you report it as settled prior to holding the mediation. Once you start the mediation process, in order for the mediator to call it settled, you need to put eyes on that document. Right. That's what I would.
No. Here's my point. They are emails that each counsel signs at the mediation saying we've reached a final settlement agreement. There'll be further documents prepared, but they're not necessary for us to have a binding settlement agreement.
All
But the
right. So
documents haven't been prepared yet. So
Right.
is the case settled or not?
And it depends. And you're the king on this one. You know this, right? So this is where it gets even trickier, right? The mediator is not responsible for determining the legality of the document that the attorneys say they have prepared and reached a final settlement. But as we all know from great case law, that if you leave too many details to be put into the final agreement, it's going to fall apart and it becomes a hot mess. And then you've got motions to enforce or motions to rescind the mediated settlement agreement, and you don't necessarily have finality. The mediator's job is to determine as much as they can without using their legal brain. So if the attorneys say, we've reached an agreement, we have final documents, we have a few details to sign off on, but this is a settlement of the case, and the mediator takes that and calls the case settled, right?
I would be
Use your best
terrified to do
judgment.
that. I would be terrified to do that.
Well, and so we encourage you to ask questions. You know, you don't have this detail in there, you don't have that detail in there, and that's where your mediation skills come in. But the point is that as a mediator, you're not supposed to judge whether or not a document is legal or not, but we are absolutely wanting you to ask the questions of, you all don't have this term in here, and that leaves a lot of discussion open. So maybe we should include these details, because the more details that are open and left on the table, the more room it has to fall apart.
But Tara, isn't one of the obligations of the mediator at the conclusion, if there is an agreement, to have a signed agreement?
Yes.
So I guess the question is whether the attorney's email is a signed agreement.
I mean, if the terms are contained in the email and everybody has electronic signatures on it, I think that again would be a question for a judge on the bench, is to determine whether or not that would be considered a legally binding document. But if all the terms, what I wouldn't be comfortable with is an email saying, hey, we've agreed on everything over here. We're just telling you we've agreed, right? The mediator actually needs to see the terms and needs to see what's in it, because the mediator then is encouraged strongly to ask the questions to say, hey, you know, we're settling this, but you haven't addressed this. You haven't addressed this. We talked about this. I don't see that in here. Can, you know, and to ask those right questions in order to pull that information out.
Because I you know, people even change their minds after you have a signed agreement. So, I mean, that's why I would always want to see a signed agreement before I said anything. But that's just me. Frank?
And the court's already ruled that the lawyer can't sign for the party. The party has to sign.
Right. Party has to sign, or they have to have a designee, and you have to have it in writing that they have designated somebody to sign.
Frank, you wanted to say
Yeah.
something?
I wanted to go back to where we first branched off, dealing with confidentiality about needing approval. And my analysis is this: if there's something that you can find in the court record, it's not confidential. So if the court record reflects that one of these people is a minor, they're a minor. And you can talk about that in the report of mediator. Now, still be as discreet as possible, but the fact that Joey is a minor is in the court record. It is not confidential. So also, if you can find it in the law, it's not confidential. So the lawyers have told me, I'm not practicing law, the lawyers have told me that since Joey is a minor, then this will need to be approved by a court. So I can say this settlement is subject to, you know, approvals as required by law. So I'm not practicing law and telling anybody what the law is, but I'm also sharing information. I'm just putting together information that is not confidential and bringing it to the court or whoever's attention. So that's my personal analysis. I don't know if Tara disagrees with me, but it seems to me that putting non-confidential information into the report of mediator that makes it clearer and more understandable and more usable for the court makes sense.
And I agree with that, Frank, because I think it's just like the procedural boxes we check: consent judgment, voluntary dismissal with prejudice or without. I think, something to think about for the forms is another box that says subject to court approval of the minor settlement, because there are so many minors, involved. And so
Mhm.
I agree, because that's, a procedural document that's going to be filed with the court. So I think you're right on that.
Yeah, and I follow the same process. And just to carry out that thought one more step, there's three primary categories where I encounter it. One is when, let's say it's an FLSA collective action or something like that. They settled everything, but it's got to be a court approval. So I'll say subject to court approval. Go back to Ann's point. And Trish's, I do a lot of employment. And so if it's subject to the Old Worker Benefits Protection Act requirements of the 21-day, 7-day revocation, all that kind of stuff, I say subject to OWBPA requirements. If it's a municipality, subject to board approval if the board has not yet met. And I think for the reasons that Frankie and Jackie just said, I think that's just simply reporting what the status is under the law as to what's required. I just don't see that crossing the line in any way whatsoever. The other way this comes up, and this is the next step, this is actually before mediation, where you get a call, the email from the lawyer saying, we don't need the mediation because we've already settled things. Now, what I'm not hearing you say, Tara, although correct me if you're wrong, at least the federal forms, I can't remember the state forms, it'll say, did you hold the mediation? And if you didn't, why? So I'll say no. The counsel for the defense reported the case settled prior to the mediated settlement conference. I don't have to see anything for that, do I? Because they reported to me. That,
Correct. Yeah,
yeah.
that's correct. That's
and
correct.
I think the
So you
same
say
kind of
for
things
lawyers
on the
work.
state form, but I can't remember.
Yeah.
I just weigh in on this. It's kind of interesting to hear. I grew up Baptist, so to me, less is more. I think there are a lot of things that are subject to conditions. I just say settled, because it's subject to payment. It's subject to approval. There could be 100 different conditions that I don't believe is appropriate to put in the box. I don't think you're required to say it. Obviously, there has to be town council approval. There has to be this, but once the mediator starts getting into the conditions around the settlement, I don't think he or she needs to do that. I just say settled, because I do.
But if you
No,
have
just
a minor court settlement, and, our forms have consent judgment, voluntary dismissal with power without, it's like, well, no, it doesn't fit.
I agree with that.
Ultimately,
Doesn't
it's
quite
without
fit.
prejudice,
Well, I just don't want boxes to rule my life. It's not a consent judgment, but there is going to be a dismissal. And
Right.
so I check that. But I think less is more. I think once you start picking, and there are obvious ones, of course, the town council got to prove this, the judge is going to have to prove that. There are many conditions for any settlement, some of which are more formal than others. But if I don't make a payment, there's still a settlement, at least as far as these parties are concerned in this process. So unlike the public waiver of whether I have mediated or not on this one, I just put it's settled or it's impasse. I'm like Ken. If you can't get it together, and I need to hear back from my friend in Oklahoma, it's still an impasse in state court as far as I'm concerned. That's fine, but I'm going to let you come back to me. I'm not going to try to keep it open, knowing what the issue is.
Right. And I think a lot of that is going to be a judgment call with mediators, and you all are trained and expert in your fields. But I think to Judge Gale's point, if you've got an agreement that says defendant will pay plaintiff $20,000 on the first of the month for the next 6 months, that's a final agreement, right? Whether or not they pay it or not is irrelevant for the mediator. But if you've got an agreement that says defendant agrees to pay $100,000, terms will be decided later, you probably don't have a final agreement, right? So, I think that's something to consider. And folks, I apologize. It's 9:25. I have a 9:30 call. I'm going to have to jump off.
No, thank you very much, Tara. We appreciate it. I will tell you in conclusion, because we've gone over, we've learned several things. One is call Tara when you have a question, because
and I'm not always right? So call me on it if I miss something.
No, she's there. I've called her repeatedly after hours and begged her for her help, and she's been wonderful. So really appreciate what you do, Tara. And we also know we probably need more than 45 minutes for this. And if you like it, if you think this is a good thing for us to do, we will host another one, but give us some feedback on that. And You know, we got through maybe 1.5 of our topics under confidentiality and inadmissibility. We did not even touch what we really wanted to talk about. But these are wonderful folks here. Thanks to everybody. Thank you to folks who participated, and we really appreciate all of you.
I'm going to
Thanks
add,
all.
Amy has a note in the chat about the sections annual pro bono survey. And so I thought I'd kind of point that out. It's open until February 5th.
That's great. That's great. So,
Thank you, Jackie. I appreciate
Great
that.
to see everybody. Thank you.
okay. Yes. Thank you,
Bye.
everybody.
you.
Bye.